Hello guys, welcome to our new page Lawyers Corner. This page is created for spreading legal awareness in our society. For any kind of legal assistance, feel free to send us email. Those who are new, please subscribe, follow our page. Today we will discuss about the legal term amicus curiae. Amicus curiae is a legal term that widely used not only in India but also throughout the world. The legal term amicus curiae is a Latin phrase that literally means friend of the court. The concept of amicus curiae came from the Roman law to the international law, and later it came to the civil law and sometimes in criminal dispute also. So what the word amicus curiae actually means? An amicus curiae is an individual or organization who is not a party to a legal case but who is permitted to assist a court by offering information, expertise, or insight that has a bearing on the issues in the case. The decision on whether to consider an amicus brief lies within the discretion of the court. So, what is the role of amicus? The role of an amicus is as stated by Salmon in Allen versus Sir Alfred McAlpine and Sons Limited. I had always understood that the role of an amicus curiae was to help the court by expounding the law impartially, or if one of the parties were unrepresented, by advancing the legal arguments on his behalf. Amici curiae that do not file briefs often present an academic perspective on the case. For example, if the law gives defense to a history of legislation of a certain topic, a historian may choose to evaluate the claim using their expertise. An economist, statistician, or sociologist may choose to do the same. The court has broad discretion to grant or to deny permission to act as amicus curiae. Generally, cases that are very controversial will attract a number of such briefs. In India, the courts have time and again welcomed the idea of permitting amicus curiae to associate themselves with proceeding generally involving public interest. By doing so, the court is guided not only by the academic perspective required for the particular case, but also enables the court to have an understanding which would allow them to do justice in its entirety. The person who is usually allowed by the courts in India to act as amicus curiae are people who represent the unbiased will and opinion of the society. In innumerable cases in India, the court have allowed or on its own motion have asked various people to act as amicus curiae to the proceedings. A very fine example of this is the famous, or rather the infamous BMW case, which has yet again been in news recently due to the fact that both the defense and the prosecution lawyers have been suspended by the Delhi High Court on charge of driving the witness to turn hostile. In the said case, advocate Arvind Nigam, who was appointed as the amicus curiae by the Delhi High Court, has played an crucial part in securing justice. The importance of amicus curiae can be well seen considering the fact of the above-mentioned case, in which both the prosecution and the defense have gone beyond ethical and professional practice to murder justice. The role played by the amicus curiae advocate Arvind Nigam in the present case can be well appreciated considering the fact that the Delhi High Court has recommended his name for the post of senior advocate. In another present case where the validity of the examination of All India Bar Council has challenged in Supreme Court, The renowned senior advocate K.V. Viswanathan also played the role of Amicus Curiae along with senior advocate and Attorney General K.K. Benugopal. In this case also, K.V. Viswanathan has highlighted all the social aspect of a All India Bar Council exam and the doubts and questions regarding it that may help the court to reach out their decision. So the word amicus curiae, which have a origin of early 17th century, has a widespread use in the modern legal system, especially in the apex court of judicial system. Considering its utilization and acceptability, in March 2002, the European Commission had submitted a proposal for the amendment of the dispute settlement understanding for providing for admission and acceptance of amicus curiae briefs on a case-to-case basis, though India is not in favor of the said proposal. In India, thus, if a petition is received from the jail or in any other criminal matter, if the accused is unrepresented, then an advocate is appointed as amicus curiae by the court to defend and argue the case of the accused. In civil matters also, the court can appoint an advocate as amicus curiae if it thinks it is necessary. In case of an unrepresented party, the court can also appoint amicus curiae in any matter of general public importance or in which the interest of the public at large is involved. So, in one word, amicus curiae is that friend of court who assists unbiasedly, neutrally to the court to reach its prudential decision. Feel free to share your knowledge with us.